Hey guys, it's your humble host, or Kid if you prefer. So I'm back with another video. This is about a case, yes, another custody case. This one is actually pretty major. It's not like the Save James, but it will set another precedent, depending on what happens. So I'm going to read an article, and then I'm going to show you some court documents. And I'm going to give you the information that I know, as I've also spoken with this father, not an interview form. I'm still trying to get that, but we'll see. But I'm going to give you the information that's been told to me thus far. So, what is going on? And this is in Austin, Texas. The judge that's overseeing this is Judge Sherry Shipman, claimed to be Republican. Okay. Okay, and you're going to find out why I just rolled my eyes. Texas Supreme Court set to hear what may be the most significant parental rights case in Texas history. So this has to do with fathers' rights again. This post has been updated, and I'm going to put the link to this article in the description, as they've been continuously updating it ever since the beginning. The Texas Supreme Court is set to hear oral arguments, which is March 24th, and this is a Supreme Court case, mind you. And a parental rights case that could shape up to be truly groundbreaking. The case known as CJC, which I'll put that link in the description as well. It's a link to all the court documents, centers around a father who is battling against a non-relative for custody of his 5-year-old daughter. This non-relative was the fiance of the daughter's now deceased mother. Actually, what would be a little bit easier here for me too is to add a bit more information as we're going through. So pretty much you have JD, or John Dummis, as he's called. That's the name of the ex. Now, what had happened was the daughter's mom, the daughter's name is Anne, the mom and this ex had gotten engaged, but it wasn't until April of 2018, so they were never married. However, there is a law in Texas, and I forgot what it's called. It gives people standing if you have a roommate, and this roommate has a child, and you stay with that roommate for about 6 months minimum, 1 year maximum, but you help take care of this child and provide and all that stuff. That gives you standing to have rights to the child. I shit you not. So anyway, what happened with the ex and the mom? The mom passed away tragically July 2018 due to an unforeseen car crash. So at the time, CJ, we're going to call him, or Chris Clay, and the mom, I forget the mom's name, I do apologize, had 50-50 custody, conservatorship. Now, there was a case going on pending where she tried to get more time, more money, and from what I've been told, this is alleged, is that JD, or John Dummis, is the one that told the mom to file to change terms of custody and that sort of thing. So let's continue. The non-relative was the fiance of the daughter's now deceased mother. Now let's also point out that Mr. Dummis is now engaged to another woman. It's been about she passed away in 2018. It's been a little over 2 years, but he's already engaged to another woman. A good relationship, at least before you get engaged, is 6 to 8 months. Think about that. What makes this case especially noteworthy is that all the parties in the case openly acknowledge that the father is an entirely fit parent. Okay, so let me add this little bit too, is because when the mom passed away, you had the grandparents of the daughter on the mom's side sue the father for sole custody. The father, Mr. Chris Clay, wanted to take his daughter Anne to a different location, move her closer to him. So, and he had 50-50 custody and conservatorship. So the grandparents, the Jacksons, took Chris, sued him for sole custody. They got booted. In the end, the Supreme Court went, yeah, no, get out of here. And then 2 weeks later, which I call this a scattershot, you have JD file for rights to Anne. He's a non-relative. He doesn't meet the 6-month requirement. He falls like, I believe, like a week or so short. So it's like 5 months and something days. So he sued. And this is a to expand, mind you. Also, let me point out in regards to the Supreme Court, is in order for you, there's, how do you put it? I believe there's 4 rounds. The first round, in order to even get your case considered for the Supreme Court, you have to have at least one justice interested. After that, whether they depend on the ruling and things like that, if it comes back for the second round, you have to get 3 Supreme Justices interested in your case. Depending on the ruling how it goes, it can come back around and get completely tossed out. The third time, you have to get 4 justices interested. So let's keep in mind and also put out there that Chris has had to go to the Supreme Court 3 different times. This is round number 4, mind you. So number 4 is the final round, and you have to get 5 justices on your side in order to win overall. So, not only did Chris got dragged to Supreme Court by his grandparents, I believe it was also by JD, and I spoke with him last night. It's been a long day at work, so if I get a little bit stuff mixed up, let me know in the comment section below. But anyway, we're at round 4. Round 4. So that says that each time, because Chris has had to file appeals, he has 2 law firms. I know one of his lawyers is Miss Holly Draper. So he has justices interested in his case on his behalf. He is in good terms. So the more that this case keeps coming through to the Supreme Court, the more you have more justices go, oh, what is this? So, and he also has the Attorney General fighting on his behalf, Ken Paxton. So this is pretty huge too, which I'm going to show you a court document because Ken Paxton filed something on Chris Clay's behalf. It's actually pretty cool. Okay, so a good father who acts in the best interest of his daughter. And by the way, Chris Clay is also married. So let's also establish that Anne, little 5-year-old Anne, has been living with Chris her whole life during that 50-50 split. And then she is accustomed to what you can consider her stepmom. I do not know the woman's name, nor would I give that out even if I did. And so if, I'm not saying this is going to happen, but this is like pretty major, and I know there's a lot of step parents who are very touchy when it comes to cases like this. I put this out on my Facebook a few weeks ago, and I had 2 people respond that felt differently, but not all the facts were known about the case. I didn't have a whole lot of information as I do now. So it is a touchy subject. However, seeing the details of this case and what I've been told thus far, this should not have even gone to court. This should have been tossed out from the get-go. I think it's ridiculous that it's had to even come this far, but at the same time, the fact that they're in round 4, Chris Clay and his 2 law firms says that he has 4 justices now going, this is kind of messed up. What's going on? Why is this even so? It's a good thing. So round 3, 4 justices, and then round 4, 5. So from what I've been told, they have a good feeling about it. No, I've not spoken with a lawyer. I usually kind of tend to stay away from that area. But so let's continue on. Nevertheless, the ex-fiance argues that he should be allowed to share custody of the daughter over the father's objections. Which, by the way, let me also point out that Anne wants nothing to do with the ex. Chris even went as far as to tell me the other night that because for some odd reason, and this is Judge Shipman, decided to grant the ex 1-day visitation or send Anne over to his house for 1 day. Chris had told me last night that Anne cried. She had no idea what was going on, why she was being dropped off at a strange man's house. And I guess this is even documented. Anne has seen a counselor due to her mom's passing and evaluation and things like that. From what Chris has told me about Anne, from what the counselor has said, is that there is no recollection by Anne, nor even any mention about the ex. Anne does not care about the ex nor want anything to do. 5-year-old little girl, she wants her daddy and she wants her new mommy. So, and you have douche nozzle coming in, and I'm going to give my hypothesis, and this is again my hypothesis. This is not fact. So a little bit what is known about the ex, JD or John Demis so far is that he has been through divorce himself. He does have shared custody with his ex of his own daughters. So he doesn't have sole custody, he has 50-50 from what I've been told, from what Chris has informed me. Also, I had spoken with other people because I got alerted by one of the other Save James people to this case, and we kind of spitballed back and forth, and I kind of had a suspicion that the grandparents were in on it. And that's something too that Chris has informed me, is that by the way, let me tell you this, when JD was granted possession or whatever you call that, and when Anne was sent to his house, she actually went to her grandparents. Now, do remember at the beginning of this video, I had stated that the grandparents, the Jacksons, tried to sue Chris Clay for sole custody of Anne. Supreme Court went, no, get the hell out of here. And then you had JD filed 2 weeks later. Okay? So again, that's why I called it a scatter shot, seeing what stuck. And for some odd reason, you have the judge that was responsible for creating this fiasco in the first place is Judge Sherry Shipman. And from what I've been told, she's also up for re-election in the next few months. She claims to be Republican. Rhino, I smell a rhino. Rhino is a Texan term I learned for fake Republican or Democrat disguised as Republican. So if you look up the term, I'm sure you can get a little bit better definition than what I just gave, but let's continue on. During the last 10 to 11 months of her life, the mother lived with her boyfriend, which let me also touch upon that is the mom moved in with Demis August 2017, and they did not get engaged till April of 2018. Now, as we've already said, Chris and his now deceased ex shared 50-50 custody and conservatorship. So that means Anne was with him 50% of the time. And then Anne was with the mom and her boyfriend 50% of the time. They only were engaged for 3 to 4 months before the mom passed. So not really a whole lot. After the mother's death, the daughter's maternal grandparents filed suit against the father seeking joint custody of their then 4-year-old granddaughter, although the trial judge allowed the grandparents' case to go forward, which was stupid. The Court of Appeals found the grandparents' case should be dismissed because they could not prove the leaving the father as sole custodian was causing harm to the child. Because they couldn't. They've already established that the father was a good fit, that leaving Anne in Chris's care completely wasn't going to do any harm to her. So appeals court went, yeah, bye. In contrast, the Court of Appeals found that the fiancé was not required to provide the same proof as the grandparents, which I have no idea why. That makes no sense to me whatsoever, and allowed his case to go forward. No idea. Despite finding that the father was an entirely fit parent, the trial still gave important parental rights and possession time to his fiancé, even though he did not meet that 6-month requirement. So he technically should not have had any standing whatsoever. In fact, the judge agreed that the fiancé's argument that he should be allowed to come before the court on equal footing with the actual father, which, by the way, is bull. The judge concurred that there should be no presumption in favor of the father's having sole custody of his own daughter. Again, this is Judge Sherry Shipman, a claimed Republican. A woman, no less. Oh. As was recently outlined in Attorney General opinion, which THCSC worked to obtain in February 2019, the constitutional right of parents to raise their children has been clearly established through 100 years of case law. In fact, the United States Supreme Court describes it as the oldest of the fundamental liberty interests recognized by this court. You'll have to excuse me, it's been a long work day. And what makes this case so disturbing, because it really is, that a non-parent was not simply given custody of another man's daughter, he was given custody on the grounds that the biological father had no greater right to custody of his own daughter than a virtual stranger. And that's true. This is scary. This really is, because you're pretty much, according to this judge, Judge Sherry Shipman, in her ruling, the father, the status of a father means no different to a child than the status of a stranger. That's terrifying. And we've already seen the Save James case and cases all around the US that fathers really don't have a whole lot of rights, or the courts are really kind of biased against them. So this does not help. Let's see. Okay. This case has far-reaching implications, and it does. If the court agrees with fiance's argument, horrible damage could be done to the constitutional rights of parents to raise their children, especially fathers. On the other hand, if the court agrees with the father's argument, which again, they're in round 4, which is going to need 5 justices, but the fact that it's made it this far in the Supreme Court is very good. So, and Chris feels very confident that they have more than 4 justices interested, and again, oral arguments are going to be held on March 24th. There's also a GoFundMe link, because this is really pricey. This is not the same price range as normal court hearings, so I will post that in the description below. Please donate if you can, retweet, share, the usual. Father's argument such a decision could thoroughly squash dissenting voices who have argued for years that the fundamental constitutional rights of parents are weak and narrow. Dissenters make these arguments despite the 100 years of case law that say otherwise. Thankfully, the Texas Supreme Court currently has at least 4 justices with a solid record of protecting the constitutional right of parents to raise their children. So you already got 4 people. Again, we are already round 3. So the final round, which round 4, they need 1 more justice to go, yeah, no, this is bull. Get out of here. Here's your daughter. Hey, stupid, get out of here. So only 5 votes are needed for the father to prevail. The court as a whole also has a long track record of protecting this right. Let's also not forget that you have, and I believe same group of people, because we had a lot of people get involved with Save James and things like that. So these cases are waking people up, not just with the trans stuff, not just with the rights, but it's just like, oh, okay, so we have people coming in and trying to degrade parental rights. Fathers is a big focus, but there's a lot of mothers too who get chucked underneath the bus by the court system. So yeah, it's a breakdown of parental rights, and we've seen this with politics, we've seen this with so many other things, that people are trying to come in and take away rights from the parents, whether it be raising them, what they learn, what they teach, who they stay with. You get the shebang. You guys have seen the cases, the articles, what we covered here on this channel. So no, it is a thing that is happening. The enormous potential of the case has not been lost on the pro-family legal community, and thank God for that. I did not hear about this case until, again, one of the other Save James people told it to me, Alan. So this has been going on since last year of 2000. Oh, not last year. 2018, possibly 2017. So, and we were preoccupied here on this channel with Save James and some other stuff. And so coming out the tail end of this, where there's a final hearing, like, hey, this is the final trial, and it's crazy. It really is. Early last fall, the Texas Public Policy Foundation and the Texas Homeschool Coalition each submitted briefs defending the father's constitutional rights to make decisions for his daughter. Again, this should not even have been allowed to come this far. Like, oh, okay, you, mother, father had 50-50 custody. Oh, okay, mother tragically passes away. Father, here you go, here's your child. You get out of here. So that's it. That should have what had happened. There should have been nothing. None of this should have gone on. But of course, we have stupid people, in the power chairs, and we got a judge who, from what I've been told, doesn't have children of her own and doesn't understand the importance here. Doesn't understand exactly what she's doing. Again, she's up for re-election. Let's see. or his daughter. THSC's brief was joined by 14 legislators and 2 other pro-family organizations. Holy cow! While the Texas Supreme Court was not required to hear the case at all, the court intervened and temporarily suspended the trial's court grant of custody to the ex while the justices considered a final decision on the case. So again, this is a good thing. This is so important because you got people in the Supreme Court, you got the Attorney General, you got legislators going like, what the hell is going on? Why are we even seeing something like this brought to our desk? So the fact that the court went, yeah, no, something is not right here. We're going to take a look at this for ourselves. And I think the father is going to win. From what I've been hearing is his lawyers have been playing it safe and doing their part to make sure that they don't rattle any cages. But this is the document, and this Supreme Court of Texas, let me make sure you can see this because I had to format my thing. Okay, you guys can. Ordered Realtor, which is Chris, Realtor's name is being referred to as Chris Clay, emergency motion for stay, meaning the daughter, Anne, is not to go over to the boyfriend's house anymore. Done. Which, by the way, let me also remind people what I said is when Anne was going over to John Dumas' house, he was actually going over to her grandparents. And apparently Chris has documentation of this. So yeah, the grandparents and the ex were in cahoots with each other. And when Alan was first telling me about this case, I had kind of suspected it because it's like they file, he files, one gets kicked out, one goes forward. It's a scattershot. Yeah. And it was, from what I understand, it was sole custody that the grandparents sued for because they didn't want Chris taking Anne to a different location. So, and that was kind of how some of this mess started to begin with, is because when Chris and his ex had their custody battle and things like that, the deceased mom, was given exclusive right to decide Anne's location. Chris had no say, so that kind of played into this mess as well. Is granted the temporary orders dated June 27, 2019 in case number 16-07 061-16, styled in the interest of Chris, I forgot his middle name, I do apologize, CJC in the 16th District Court of the Denton County, Texas, are stayed pending for the order of this court. The party shall file their brief on the merits according to the briefing request schedule. The petition for writ of Menendez remains pending before this court. Again, I've had a long day, so if I'm flubbing around, I do apologize. But yeah, so you had the court intervene on this going, something is not right here. What is going on? We're going to have a look at this. This is all on hold, which is actually pretty cool. So, after the court's temporary order, additional pro-family organizations lined up to support the Father's Constitutional Rights Alliance, Defending Freedom, the Parental Rights Foundation, and a Voice for Choice Advocacy all submitted supporting briefs. Man, the state of Texas also submitted a brief defending the father's constitutional rights. Following this litany of supporting briefs, the Texas Supreme Court has now scheduled this case for oral arguments, March 25th. Representatives from THSC will be the attendants at the hearing. While the battle is far from over, the strong support for this father's right to raise his daughter, as well as the pro-family record of several Texas Supreme Court justices, provides hope that this could be the most significant and beneficial parental rights case Texas has ever seen. So the fact that you have so many people get involved, and the fact that the court went, hold up, we need to look at this, that it's really, really telling. So that not only spells out, hey, this is BS, what's going on, it also speaks well of Chris Clay's law firms. His first one was Miss Holly Draper. I do not know the law firm name of the second one. I do apologize. So let me click on a few here. Alliance Defending Freedom. Holy cow, those are big dogs. That is a big dog. And if you guys don't know who those guys are, the ADF is responsible for, like, you guys remember Jack Phillips, the cake artisan in Colorado who kept getting sued 3 times by the quacky lawyer, so-called lawyer. Yeah, no, they have worked with Jack Phillips. They go in and they defend people like religious freedom and things like that. Yeah, no, they're a big deal. Let's see, oral arguments. Okay, so let me click. So this is the court document here. Again, I'm gonna check my OBS. Yes, okay. So Miss Holly J. Draper, that's his first law firm. And then Miss Michelle May O'Neill, so I'm gonna assume that's the appellant, delivered via email. Today, Supreme Court of Texas reset the above referred calls for oral submission at 9 a.m. So this is 9 a.m. sharp. Wednesday, March 25th, 2020. Counsel should be present in the courtroom by 8:30 a.m., half an hour early, for check-in with the marshals. Oral arguments begin at 9. If desired, counsel may call the clerk's office for the order of setting on Friday, March 20th, 2020. For the order. Oh, okay, so that should be, if I understand this correct, if desired, counsel may call the clerk's office for the order of setting on Friday, March 20th, 2020. So that may be when the final verdict is going to be given. Now, I don't know, because I know just from my little experience with St. James, the ruling was set off for a few days. Sometimes the ruling can be given right there on the spot, or it could be so. Each side has been allotted 20 minutes for oral argument. Oral argument would be held at a location in Supreme Court building at 201 West 14th Street, corner of 4th and Colorado. This would be a case to cover. I'm not saying St. James is it, because that was also significant, but this one, I wish I could be in Texas for this one. This is cool. This really is cool. So, and this must be dude's lawyer. From what I understand, and this was alleged, this was told to me, and I have not verified it just yet. You can see it on the previous court documents, but I think the deceased mom and the ex shared the same lawyer. I'm not sure how true that is. You'd be able to verify that on the earlier court documents. I will put that link in the description below. There was one other thing I wanted to show you guys. This is, if I remember, I think this is the Attorney General's brief. Let me see. Justice Lee Gabriel. Oh no, this was the justice that tossed out the grandparents' filings because they were not able to prove that Anne being put with Chris solely would do her any harm. There's one other thing I wanted to show you guys, and I know this is a long video. This is really important, but you can find all the cases, all the court docs. And let me see, there was 1 and 2. Okay. So, because I spoke with him last night, I won't be able to show everything. 5, 1 through 2. Okay, so, and they cite a Traxel case, and it's similar to this one. This one, the Traxel case was ruled 2018, 2019. It had to do with something similar, and it had to do with a set of grandparents. Look it up, but the grandparents had some sort of standing, and it set some flimsy precedent. But yeah, so Dumas is using the Traxel case to claim he has standing. Argument and authorities. Reply issue 1, chapter 156 passes constitutional muster. The U.S. Supreme Court's limited mandate in Traxel was made in the face of a statute that was breathtakingly overbroad with little to no procedural or jurisdictional barriers. So, meaning the ruling of Traxel is way too broad, way too vague, not detailed enough. The Washington statute issue in Traxel read as follows: any person may, and this is kind of garbage, any person may petition the court for visitation rights at any time, including but not limited to custody proceedings. The court may order visitation rights for any person when visitation may serve the best interest of the child, which in this case the ex needs to go away, needs to go bye-bye. Rights for any person when visitation may serve in the best interest of the child, whether or not there has been any change of circumstances, which is bull. Troxel versus Granville, 530 U.S. 5761 2000. The U.S. Supreme Court held that the visitation statute was breathtakingly broad. The primary issue with the Washington statute were the Washington statute gave no difference to the parents' fundamental rights or decision concerning visitation. The language of the Washington statute permitted any third party to seek visitation of a child, which is actually kind of scary, by the way. The statute had no requirement that there be changed circumstances. Finally, the Washington statute's best interest of the child standard has been interpreted broadly and does not include any specific factors. Ultimately, the problem with the Washington statute was not whether a trial court may intervene, but the circumstances under which a trial court may intervene. The U.S. Supreme Court's mandate in Troxel is limited. We do not and need not define today the precise scope of the parental due to process right in the visitation context. In this respect, we agree with Justice Kennedy that the constitutionality of any standard for awarding visitation turns on the specific manner in which that standard is applied, and that the constitutional protections in this are best elaborated with care. Because much state court jurisdiction in this context occurs on a case-by-case basis, we should be hesitant to hold that specific non-parental visitation statutes violate the due process clause as per se matter. And then Chapter 156 is not unconstitutional because Texas statutory scheme addresses every issue with the statute at issue in Troxel and narrowly tailored. So yeah, it pretty much, it should be a case-by-case basis, not a broad term overall. But with Troxel, as it was explained to me, as it created this way too broad precedent for any third party to go, hey, I want visitation rights with this kid. So again, it's too vague. There's not much to go off of. Let me show this too, and I'll wrap it up here because I gotta go do some stuff, and we're already at 32. Okay, so this is briefs the state of Texas as amicus curiae in support of Realtor, again, in support of Chris Clay. Identity parties: Ken Paxton, Jeffrey C. Meter, Kyle D. Hawkins, Natalie D. Thompson, lead counsel, Office of the Attorney General. So yeah, it's kind of a big deal. How many pages are these? Blah, blah, blah. So as you can see, he filed his own. Again, this will be in the description as well, because it's a very specific document. It's dated for, let me pull up my file, dated for 12/16 of 2019. But statement of facts: mother and realtor father were joint managing conservators of the child, again 50-50, also 50-50 custody. Each had roughly equal rights to possession. Mother later filed over father's objection a petition to modify the custody order to change child support arrangements. She wanted more money, she wanted more time, and I was told this was because Dumbass told her to file, allegedly. While that modification proceeding was pending, mother tragically died in a car accident, so it never went through. Child therefore thereafter resided solely with father. So again, she went with Chris, as she should have. Chris's maternal grandparents and mother's live-in boyfriend, fiance of 3 months, JD sought to intervene in the modification proceeding. The trial court determined that each had standing to seek relief. Upon mandamus review, the Fort Worth Court of Appeals had that grandparents lacked standing to seek conservatorship. So they pretty much said no to grandparents, but the Court of Appeals held that JD did have standing to seek custody rights based on sections, and he didn't meet 6 months. He wasn't married. And here's the thing that I don't know, because I don't have any that sort of thing in front of me, and I've yet to see any exhibits. There's no documentation of what he paid for in regards to and what he contributed financially. I haven't seen anything yet. I've gone through some of these court documents. I haven't seen anything in there either as far as exhibits and things like that. But again, all this is going to be in the description, and I'm going to try to get an interview with them. We will see whether it's before the hearing or after, but this is really, really, really important because this is also another case that will set a precedent. And the precedent that it's going to set is whether or not a third party can just come up and claim rights to your child, whether it be custody, possession, conservatorship, whatever. So again, it cites another case, Proxel, and from what I understand and what was listed in that court document I just read, is that it, instead of doing a case by case, it did a broad term. So it pretty much put father, mother on the same platform and standing as third parties, which is BS. So tell me your thoughts below. I will link again everything, the GoFundMe, this article, the link where you can find other court docs yourself. So yeah, no, this is a pretty big deal. This is another attack on parental rights, slowly breaking down. But again, Chris is confident so far they're in round 4, so they need 5. They need one more justice to go. Yeah, no, this is bull. Here's your daughter. You idiots, get out of here. You're done. So anyway, I'm sorry this was a long video. There's a lot to go over, and I still didn't show everything that I'd wanted to or talked about with Chris because there's like so much here, and I'm still trying to wrap my brain around the stupidity of this entire freaking case because it's just freaking wackadoo. But you know, family court, there's never any common sense in family court, and we've seen this. We saw this with the Daddy of 5. We're seeing this with Save Miles. We saw this with Save James. We're still seeing it with Save James, by the way, and then we're seeing it with this one. And oh, also Justice for Cars Kids. We're seeing it with that one as well. So anyway, you guys have a wonderful night. I'll catch you guys in the next one, and if I do get an interview, an audience with Mr. Chris Clay, I will let you guys know. So, but yeah, please pass this around. This is a really big deal. This is another case that you need to keep your eyeballs on. Anyway, see ya.